Hey everyone, it's Julie Kruger from Kruger Immigration Law. I hope you're having a great day. So we have been seeing a lot of really difficult processing with USCIS recently, and I'm sure many of you out there have as well. So I wanted to tell you about a case recently that we had that we were able to successfully get our client's case reopened and get our client her green card after some really difficult processing with USCIS that they had gone through on their own. So our client is originally a citizen of country from Europe, and she came to the United States on a fiancé visa. She applied for adjustment of status and got her green card through her spouse, and she got the 2-year green card because they had been married for less than 2 years at the time that they were married. And so 2 years later, they filed the Form I-751, the petition to remove conditions on permanent residence. They filed it on time. They filed it with their good evidence, and it processed with USCIS for a while. And then one day, early last winter, they received a denial letter in the mail, and they were really shocked. And this is a married couple who lives together. They have a baby together. They have a strong relationship. They felt like they had submitted good evidence and they didn't know what went wrong. And reading through the denial, it turned out that USCIS said that they had sent them a request for additional evidence, and that they had not responded to that request for additional evidence. And therefore, USCIS was considering their case to be abandoned and were denying it on that basis, that they hadn't responded to the request for evidence that they had received. Now, they were shocked. They hadn't received a request for evidence. They had moved during the process, but they had submitted online address changes with USCIS as soon as they moved. They did exactly what they were supposed to do. So they were concerned that this request for evidence obviously had been sent and they hadn't received it. They had done what they were supposed to do in submitting the address change, and USCIS had denied their case. And of course, the denial says very clearly, you're no longer a permanent resident. You don't have the right to live and work in the United States. You should depart the United States immediately. And if you don't, we're going to place you into a deportation proceeding. And again, this is a family, a married couple living together with a new baby. They certainly don't want her to be in a deportation proceeding and deported from the United States. So they contacted our office to see what we could do to help. And at Kruger Immigration Law, we have really extensive experience in immigration cases. It's the only kind of case we do. And we handle hundreds of family-based cases every year. And so, we were able to do a little bit of research on their case and make sure, first we wanted to make sure that what they were saying was accurate, that they had submitted the address change on time, that they had filed the petition on time, that everything that they thought that they had done right, that they truly did do right. And we determined they were right. They did what they were supposed to do. USCIS had sent the request for evidence. They hadn't received it. So what we did, we came up with the strategy to fix their issue. So immediately, within the time that was required, we filed the Form I-290B, the Notice of Motion, and that is a motion to reopen their petition, saying to USCIS, you did this wrong. USCIS, you made an error, and you said you sent a request for evidence that they didn't respond to, and that's not correct. If you did in fact send it, you sent it to the wrong address because they gave you the correct address. Maybe you never even sent it at all, but in any case, the couple didn't receive it. They didn't fail to respond, and this denial is in error. Now, along with showing USCIS that they were wrong, we also wanted to make sure that we showed that this couple has a real relationship, that they did meet all of the requirements of the I-751 petition. Because obviously, if USCIS had sent a request for evidence, it meant that there was some part of the case that they weren't satisfied by. And since the most common request for evidence that we see in the I-751 is for additional evidence that it's a bona fide relationship, and we couldn't see any other issues with this particular case, We assumed that that's what USCIS was concerned about with this petition. So we took the extra step in this case, even though it wasn't required for that I-290B, to submit a substantial package of additional evidence showing that this couple is residing together in marital union, that they had been since the time that she had gotten the green card, showing that they had a child together, they had merged their residences, their finances. We spent a lot of time putting a really strong package together of evidence to show their relationship. So we submitted that to USCIS with the correct filing fee, with all of the supporting documentation, all the correct forms. USCIS receipted it in, and about 3 to 4 months later, we got an approval notice that USCIS reopened the case. That's what happens with the I-290B. USCIS approves it in the sense that they reopen the case. And at the same time, we also got an approval notice for that I-751. So her I-751 was granted, and she was issued the 10-year permanent resident card. She'll also now be eligible for United States citizenship because she's been married to a United States citizen and living in marital union with that person for 3 years. So it was a really exciting result for us. We were so grateful to be a part of our clients' process to help them fix their situation that had gone wrong with USCIS through no fault of their own. USCIS had done something wrong. They didn't know how to fix it, but they knew that they had a real relationship, were truly living together, and that they wanted to remain together in the United States for themselves and for their child. So we were really excited to be able to represent them successfully in this case. If you have an immigration case and you'd like to speak with us about your case, give our office a call. My phone number is 716-393-9878. We offer a free case evaluation for most types of cases. We also offer a consultation if you want a longer call, up to an hour. And we'd love to speak with you about your case, to talk about the details, to figure out the best strategy for you, and to get started working on your case. We are ready to assist you. We have extensive experience with immigration cases. Let's work together to achieve your dreams without borders.